You could read every page of a business law textbook and still walk away confused, not because the concepts are hard, but because the vocabulary is a wall standing between you and understanding. Master the language of business law, and suddenly contracts make sense, court cases click, and you can actually talk to a lawyer without nodding along pretending you understand. Today we are breaking down 15 to 20 essential terms drawn from all 14 chapters of Business Law 1 Essentials. Stick around, because by the end of this video, the legal world is going to feel a whole lot less intimidating. Theme 1. The legal system and how it works. Let's start at the foundation. Before you can understand any specific law, you need to understand the system that creates and enforces it. First term, common law. Common law is judge-made law that develops through court decisions over time, rather than being written by a legislature. When a judge decides a case and sets a precedent, that ruling becomes part of common law. Think about how courts have repeatedly ruled on what counts as a reasonable business practice. Those accumulated decisions shape what businesses can and cannot do today, even without a specific statute covering every situation. Second term, precedent, also called stare decisis. This is the legal principle that courts should follow earlier decisions when facing similar cases. If a court ruled 10 years ago that a certain type of contract clause was unenforceable, a judge today will look at that ruling and likely reach the same conclusion. Precedent creates consistency and predictability in a legal system. Third term, jurisdiction. Jurisdiction is a court's legal authority to hear a particular case. A court in Texas, for example, generally cannot decide a case involving parties and events entirely based in New York. Getting jurisdiction wrong can throw out an entire case before it even begins. Theme 2. Disputes and how they get resolved. Fourth term, alternative dispute resolution, or ADR. ADR refers to methods of resolving legal conflicts outside of a traditional courtroom, things like mediation and arbitration. Many business contracts today include an ADR clause requiring the parties to attempt arbitration before they can sue each other. It saves time, money, and keeps sensitive business information out of public court records. Fifth term, arbitration. Arbitration is a specific form of ADR, where a neutral third party, the arbitrator, hears both sides and makes a binding decision. Many credit card agreements and employment contracts require arbitration. When you signed up for that credit card and clicked, "I agree," there is a good chance you agreed to arbitrate any future disputes rather than sue the company in court. Sixth term, mediation. Unlike arbitration, mediation is non-binding. A mediator helps the parties communicate and find a resolution, but cannot force a decision. Labor disputes between unions and companies often go through mediation first, giving both sides a chance to settle before things escalate. Theme 3. Ethics and constitutional foundations. Seventh term, corporate social responsibility, or CSR. CSR is the idea that businesses have an obligation not just to make a profit, but to act in ways that benefit society, employees, and the environment. A company that voluntarily reduces its carbon emissions beyond what the law requires, or that donates a portion of profits to community programs, is demonstrating CSR. It is not just about being good. Studies show consumers increasingly choose brands that demonstrate genuine responsibility. Eighth term, due process. Drawn straight from the United States Constitution, due process is the legal requirement that the government must respect all legal rights owed to a person before depriving them of life, liberty, or property. If the government wants to shut down your business, it cannot just show up and lock the doors. You are entitled to notice and a fair hearing first. Ninth term, equal protection. The Equal Protection Clause of the 14th Amendment requires that the government treats similarly situated individuals the same way under the law. In a business context, this means a state cannot create regulations that unfairly target one group of business owners over another, based on race, religion, or other protected characteristics. Theme 4. Criminal and tort liability. 10th term, white-collar crime. White-collar crime refers to non-violent crimes committed in a business or professional setting, typically for financial gain, fraud, embezzlement, insider trading. These are all white-collar crimes. Think of the Enron scandal, where executives manipulated financial statements to deceive investors. The people involved faced federal criminal charges, not just civil lawsuits. 11th term, tort. A tort is a civil wrong. not a crime, that causes harm to another person, giving that person the right to sue for damages. There are intentional torts, like fraud or assault, and unintentional torts rooted in negligence. If a company's poorly maintained parking lot causes a customer to slip and suffer a serious injury, that company may be liable for a negligence tort. 12th term, negligence. Negligence is the failure to exercise the level of care that a reasonable person would use under similar circumstances, resulting in harm to someone else. To prove negligence, 4 elements must exist: duty, breach of that duty, causation, and damages. Negligence is one of the most common bases for lawsuits in the business world. Theme 5. Contracts and sales. 13th term, consideration. In contract law, consideration is what each party gives up, or promises, in exchange for the other party's promise. It is the thing of value that makes a contract legally binding. If you promise to pay a vendor $500 and they promise to deliver supplies, those mutual promises are the consideration. A contract without consideration is generally unenforceable. 14th term, breach of contract. A breach occurs when one party fails to fulfill their obligations under a valid contract without a legal excuse. If a supplier promises to deliver equipment by a specific date and simply does not show up, that is a breach. The non-breaching party can then sue for compensatory damages to cover what they lost as a result. 15th term, the Uniform Commercial Code, or UCC. The UCC is a set of standardized laws adopted by most U.S. states that governs commercial transactions, particularly the sale of goods. When a retailer buys inventory from a manufacturer, the rules governing that transaction likely fall under the UCC, which makes business dealings more predictable across state lines. Theme 6. Employment, Regulation, and Beyond. 16th term, at-will employment. In most U.S. states, employment is at will, meaning an employer can fire an employee for any reason or no reason, as long as it is not an illegal reason like discrimination. Likewise, an employee can quit at any time. This is why written employment contracts that specify termination conditions are so valuable for both sides. 17th term, antitrust law. Antitrust laws are designed to promote competition and prevent monopolies. The Sherman Antitrust Act is the cornerstone of U.S. antitrust law. When regulators investigated whether major tech companies were using their market dominance to squeeze out competitors, those investigations were rooted in antitrust principles. 18th term, securities regulation. Securities regulation involves federal and state rules governing the buying and selling of investments like stocks and bonds. The Securities and Exchange Commission, or SEC, enforces these rules. Insider trading, using non-public information to buy or sell stocks, violates securities law and can result in criminal charges and massive fines. 19th term, treaty. In the context of international business law, a treaty is a formal agreement between 2 or more nations that can govern trade, intellectual property, or dispute resolution. When a U.S. company does business in another country, international treaties may determine which country's laws apply and how disputes will be handled. 20th term, deceptive trade practices. These are misleading business behaviors that the Federal Trade Commission actively monitors and penalizes. False advertising, bait-and-switch schemes, and misleading product labels all fall under this category. The FTC can issue fines and require companies to run corrective advertising to fix false impressions they created in the marketplace. There you have it, 20 essential terms that span the entire landscape of Business Law 1 Essentials. These are not just vocabulary words. They are the building blocks of every concept you will encounter in this course. The more comfortable you are with these terms, the faster everything else will click into place. If you want to go deeper on any of these topics, head back to the individual chapter videos in this playlist. Each one breaks down the concepts you just heard, with even more detail, examples, and context. Drop a comment below telling us which term was most surprising to you. And make sure you subscribe so you never miss a new video. Keep building that legal vocabulary. It is one of the most valuable tools you can have in business.